The High Court in Pretoria has reserved judgment in the DA's challenge of the Employment Equity Amendment Act. In its heads of argument, the DA claims that Section 15A, as amended, violates the rights of coloureds, Indians and white people. In another key argument, the party says the draft legislation was tagged incorrectly, making it invalid. But the Deputy Director General in the Department of Employment and Labour, Thembinkosi Mkalipi, is convinced that the DA is selective in its reading of the Employment Equity Amendment Act. Bagraim, who speaks for the DA on employment and labour matters, says the department has created a mess.
The reality is that it's got worse and worse, and now to set it in stone, because it doesn't matter what the employer says. If the employer says, I'm going to set a target for myself for year 1, year 2, but at year 5, they have to hit the minister's target. It's cast in stone. That's the way it's written, and that's why 15A is actually unconstitutional. The whole idea of the legislation is to call for redress. The Democratic Alliance wants very carefully to call for redress, but real redress, not redress that doesn't happen. Doesn't want to call for redress that goes worse every year. And Mr. Mkalipi can say what he wants, but the bottom line is those targets are set. And once a target's been set, the minister's not saying, don't worry, if you've got some good reason as to why you can't find people, we'll change the target. That's not the way it's worded. She's going to have to go back to the drawing board and reword it if that's the way they're trying to argue it. But even his own lawyers in the courtroom did not argue that. They're saying themselves that it might be unconstitutional. And we're going to obviously hear from the court now. It's no good us arguing the law itself, but we've got a real problem. We've also put in another plea in this particular case, that it's not been properly pleaded through the courts, through the parliament itself. It's not been tagged properly. So that's another constitutional point that we're making, in the sense that it's supposed to go through Section 76 and not 75, and it's a mess. The whole thing's a complete mess.
It's very disappointing. Mr. Bagraim is a lawyer. She should understand what the law says. First, let's start with the law. The law says any employer that is implementing this legislation must use regional and national demographics. That's the issue. That's what the law says as we speak. The regulations that have been published says a company must make a selection. When they decide, the minister set the 5-year target and said in 5 years we should be here at point A. The company then must decide how it would reach that point A. Company A would say, well,